fine. That was where I was headed next.
Great. Excellent. I'm going to stand because
Okay.
I have to in
Of
order
course.
to talk. So thank you, everyone. My name is Valerie Termini. I'm the Chief Deputy Director of the California Department of Fish and Wildlife. And so the Law Revision Commission study of the code has been underway my entire tenure as Chief Deputy Director since 2018. Also, I was the Executive Director of the Fish and Game Commission since 2016, and it's been underway that whole time as well. Essentially, we've been here for about a decade, which I won't tell you where I was in 2012, but it wasn't here. And, you know, I think it's important to remember what brought us here, which was the legislative recommendation to look at our code and see if there's a way to make minor changes to it to help reorganize it and make it a little bit cleaner. And I think we've done that. I think your staff has worked tirelessly with our staff to really make some substantive changes that have actually resulted in meaningful results. And I'm going to go through a little bit of that. So one of my roles as Chief Deputy Director is to help us work more efficiently as a department. We went through something called the service-based budget analysis, which was a direct result of one of your reports where your staff and our staff have gone through and identified a suite of unfunded mandates throughout the code that we are responsible for implementing. And that study essentially showed that we are funded at 1/3 the level we're supposed to be funded at in order to accomplish our mission. And our mission is huge. Our mission is great. I'll read it for you. The mission of the Department of Fish and Wildlife is to manage California's diverse fish, wildlife, and plant resources and their habitats upon which they depend for their ecological values and for their use and enjoyment by the public. Basically, we're charged to protect California's nature. If you don't know, California is one of the most biodiverse places on the planet. In the lower 48, we are the most biodiverse place in the United States. That takes a lot of work and a lot of protection. Think about the places that you all know and take for granted, as well as me. The coast of Big Sur, Yosemite, the Sierras, the Monterey Marine Protected Areas, right? All of these we are responsible to manage and protect. And our department plays a critical role also in protecting these landscapes for the future and these species for the future. That mission is really unattainable and is increasingly under threat from climate change, which is also exacerbated by wildfires and our current drought. Our current drought that has parched California and the American West for much of the past 2 decades is the driest 22-year period in at least 1,200 years. Our scientists, some of our scientists, as well as others, have measured the moisture patterns looking at tree rings, and they've concluded the West is in a mega drought, the likes of which have not been seen in the region since 800 AD. The Vikings sailed across North America, the North Atlantic, and the Mayans built temples in Mexico and Central America. An example of how our staff are dealing with that, we are literally picking up salmon out of the Sacramento River and trucking them over to dams where we're hoping that the water will be cooler because we're predicting that the rivers are going to be too warm and not have enough oxygen in weeks. Directly related to drought is wildfire. A new United Nations report warns that the number of extreme wildfires is expected to increase 50% globally by the end of the century, and that governments are largely unprepared for this burgeoning crisis. In order to minimize the risk to California of these extreme wildfires, we have to be better prepared. With the governor and the legislature's leadership, California is investing more than ever into this fire risk reduction, which our department is directly involved with. We have to work with our local communities. We have to work and strengthen our understanding of the intricate ecological interactions. And that's something our scientists directly work on a day-to-day basis. The only way our department can close the gap between our current staffing and resource levels and our mission-based needs is to be more strategic about how we spend our limited time and our staff resources. The value the Law Revision Commission study of the Fish and Game Code cannot be overstated. But now, a decade later, we've reached a juncture where the benefits of this work do not outweigh our duty to the mission, to our mission, and to the California public. Much has changed since 2012 when our work began. We've realized the benefits of the staff time that CLRC and our department has put into this effort so far. We look forward in working with you on what will be a sweeping amendment to the existing code. However, further reorganization will not benefit the department, our mission, the public, and quite frankly, the environment. I'd like to ask our law enforcement chief, David Best, and Wendy Bogdan, our general counsel, to explain why this is not just an issue of staff time, but why further reorganization does not result in the improvements to the code we are all trying to accomplish. Thank you very much.
Good afternoon, commissioners. David Best, I'm a deputy director with the Department of Fish and Wildlife and the chief of our law enforcement division. And on behalf of the law enforcement division, I'd like to acknowledge the commission's achievements over the last 12 years in proposing clarifying changes that are now put into place in the Fish and Game Code sections. But I urge the commission to terminate any additional efforts to reorganize the code. Any benefits of reorganization would be far outweighed by the costs of unintended consequences, confusion, inefficiencies, and substantial redirection of the department's resources for the achievement of its mission. Specifically, as it relates to our law enforcement officers, additional changes to the code will create greater difficulty for officers in the field to utilize the code for the purposes of citing, enforcement authority, potentially creating an extension of law enforcement contacts with constituents in the field, as well as potentially creating officer safety issues for those officers in the field, while providing no additional protection to the natural resources of the state of California. The commission's proposal to distinguish between resource protection sections versus hunting and fishing sections, and to use this distinction to guide the proposed reorganization, is divisive for our constituents and reflects a misunderstanding of both the code and resource management in the state, where our remaining open spaces are often agricultural or recreational lands. For example, the commission proposes to move section 2000 to a division that only applies to birds and mammals. Section 2000 makes it a crime to kill any wildlife, including fish, reptiles, and amphibians, except as provided in the code. This is the heart of the Fish and Game Code and the cornerstone of DFW's authority. It is a frequently cited violation by wildlife officers in the field, and it applies to everyone. Your staff's proposal to move the section 2000, along with several other sections that either have nothing to do with hunting or apply much more broadly than hunting, are not consistent with the multifaceted mission of the department and the reality that sound resource management includes both consumptive and non-consumptive users. Thank you. I'd like to invite up our chief counsel, Wendy Bogdan.
Thank you.
Thank you. Brian, we don't want to call you to task.
You don't want to do what?
Call you to task.
Oh, okay.
I would like to echo the comments of Chief Deputy Director Val Termini and Chief Best, and also just add a bit more detail as to why this is the appropriate moment for the Law Revision Commission to declare success and pivot to other reorganization efforts while working with the Fish and Game Department staff on the hundreds of pending text changes in place. The department has fully complied with its obligations under the government code to give the commission full information and reasonable assistance. Just building a little bit on the information on the overview Val gave. In the last 3 years, which has been a lull in the Revision Commission's process, our legal office alone has dedicated over 2,000 hours to assist the Law Revision Commission. Why? It's because even small changes to the code require extensive review. Chief Best, you did a wonderful job of just illustrating with that one small section of the code, the potential consequences, but identifying the full consequences of those changes would require a consultation with at least a dozen DFW attorneys, given the breadth of those sections and how many issues they touch upon, and a corresponding number of enforcement, wildlife, and marine staff that would otherwise be doing the work that Chief Deputy Director Termini described. I'd also note that the proposal, just for those sections, affects several recent and popular bills that the legislature recently located just where they are. Setting aside that the proposed reorganization diverts resources away from mission-based activities that Chief Deputy Director Termini described, The pending proposal, despite the Law Revision Commission staff's best efforts and intentions, misunderstands key sections of our code, as we've described this afternoon and also in the materials that I provided back in April. And in addition, is contrary, as Chief Best mentioned, to a fundamental tenet of natural resources law, that hunting and fishing are part and parcel of conservation, not separate and apart. That principle is articulated in the North American model of wildlife conservation, which animates so much of our code, as well as in numerous specific code sections. Examples, and these are just a few that I pulled out, would include the private land management program, the wild pig management program, the trout management program, as well as numerous land acquisition programs that are funded through hunting and fishing. These are not isolated examples, but instead reflect the long-standing recognition of hunting and fishing as part and parcel of conservation. They also reflect the future of conservation in California, which through programs such as the Safe Harbor Agreement Program, the Natural Community Conservation Act, all recognize the synergies between consumptive and non-consumptive resource management to achieve conservation goals. I want to acknowledge that the challenges with the proposed reorganization does not reflect any failure or shortcoming of CLRC staff, but instead reflects the fact that we've already exhausted the reorganizational changes that are appropriate for this body. The types of reorganizations that the Law Revision Commission is raising now, even with these more limited proposals, are better suited for the typical legislative process that provides more of an opportunity for a variety of different stakeholders to participate in a familiar process of conversation and input. But most of all, I want to emphasize that the commission can declare success and be comfortable that with all of the work it has done to date and the bill that is likely to move forward based upon current efforts to the text changes in place, has fully complied with the direction it received from the legislature. Thank you. I don't know if there are any speakers or any folks participating remotely who might want to speak to.
Megan's checking for us. We have a hand up.
Any hands, if folks
4 hands.
remote?
5 hands.
Okay, so there are 5, she says. So maybe take them in turn, Megan, and tell us as you allow each person to speak their name.
Okay, I'll start with Mark Henley.
Mark Hanley wrote us a couple of letters from California Waterfowl.
Okay, Mr. Henley, I think you should be live.
Hi, can you hear me?
Yes.
Great. Yeah, I'm Mark Henley with California Waterfowl Association. We're a nonprofit conservation organization that represents sportsmen and landowners who are subject to the laws and regulations under the Fish and Game Code. We also participated in the Department of Fish and Wildlife strategic vision process, and we're heavily involved with that for a time. By the way, I'm also speaking on behalf of several other groups. I'll just quickly name them: Rocky Mountain Elk Foundation, Congressional Sportsmen's Foundation, California Deer Association, Sassoon Resource Conservation District, California chapter of the Wild Sheep Foundation, the San Diego County Wildlife Federation, and also the Tulare Basin Wetlands Association. And I'll be brief here. We appreciate the significant efforts of the commission thus far to reorganize the code, and believe that you've left it in an improved condition over what it was 10 years ago. So thank you for that. That's definitely some great work, and it was much needed. But at this point, we don't believe that additional work is needed, and fear that potential confusion resulting from further changes will occur. Many of the department's stakeholders like us rely on ready access to the code, and it's not clear what the benefit will be by simply making the code read better. Further reorganization may make it harder for us to communicate to our own members what is legally required of them in the field, and thus leave them more prone to inadvertently violating the myriad of fish and game rules that they're subject to. And recognizing that many of the Fish and Game violations are misdemeanors rather than mere infractions, it's particularly important that there is no confusion in our view. We also agree with Chief Best that the department's law enforcement officers, for them, revising the code is counterproductive. For officers in the field to spend extra time looking for particular code sections to determine whether an offense was committed, issue citations, or educate the public is unproductive and possibly even dangerous. So I'll stop there and just thank you for the opportunity to comment.
Thank you.
Next one, Kimberly Delfino.
Okay.
Great. Can you guys hear me?
Yep.
Great. Thank you so much. And good afternoon. I'm Kim Delfino. Formerly, I was the program director for Defenders of Wildlife in California for over 20 years. As part of my efforts, as part of the Defenders of Wildlife program director, and I'm here speaking on behalf of Defenders of Wildlife as well as the California Native Plant Society. But I was deeply involved in the strategic vision process, and I have followed the actions of the Law Revision Commission. And I just want to echo the comments that have been made before in terms of, showing deep appreciation for the efforts of the Law Revision Commission in the changes to the code already.
Okay,
You have, it has resulted in 2 cleanup bills, and it is a real, and you have, I think, achieved a benefit. However, as noted by the department and others, the department is severely understaffed, and the service-based budgeting effort has clearly demonstrated that it is a department that is severely under-resourced. And as already noted by the comments of the department, they are facing some very severe and significant issues in the state. We have fire and drought. We have a biodiversity crisis. At the same time, we have real opportunities that are going to require lots of effort in terms of a new state goal to protect 30% of California's lands and waters by 2030, a revision of and a review of the marine protected areas, and all of the work that they need to be doing in terms of biodiversity conservation, and all the funding that's now available to do restoration work and remediation work on department lands and in other parts of the state. But this is going to require the department to have staff and attorneys available to do that work. And so for that reason, we think that at this point in time, after 10 years of effort, the time has come to declare victory, to move on and to allow the department to focus its efforts in fulfilling its extreme and vast mission, and to complete what's in front of you thus far in terms of the reorganization, but not proceed any further. And we actually think that, again, as pointed out by the department and others, that ultimately will produce far more significant benefits on the ground. And that's where we need to have that happen. So appreciate you allowing me to take the time to comment, and thank you.
Thank you.
okay. Next on the list is Patrick Foy.
Okay, Mr. Foy.
Oh, sorry about that. I think I just, I was on mute for a second.
Yeah, you're good.
Commissioners and Director Hebert, my name is Patrick Foy with the California Fish and Game Wardens Supervisors and Managers Association. We manage and supervise the bulk of the wildlife officers who write the citations under these code sections. We urge well, first I want to say thank you to the commission and staff for the enormous amount of work done. It has been a great effort, a combined effort. I also want to acknowledge Chief Counsel Bogdan, her effort and the effort of her staff. I think she just said 2,000 hours. I didn't even realize it was quite that much. That is, we've got some really, really wonderful staff in the Office of General Counsel, attorneys who have been there for decades. And I'm so confident that the work that they have done with your staff, the commission staff, has brought us to a place where we've seen an improvement. It's workable. We support what has been done. But we believe that, I think, to sum up what Chief Best stated, that any kind of further work on this would begin to result in diminishing returns, if not create outright confusion and difficulty. So just want to urge the commission to, I think Chief Counsel Bogdan said, declare success. Let's call this good, and we urge the commission to terminate the project and declare success. Thank you for your time.
Thank you.
Okay, next on the list is Jennifer Fearing.
Jennifer Fearing. Go ahead.
Hi there, can you hear me?
Yes.
Thank you so much. It's nice to see you again, Mr. Simpson, and welcome.
Nice to hear you.
Yes, yes, hi. I just want to echo all of my colleagues. I was just thinking, we're all in different jobs than we were 10 years ago. I too was served as in the 2-year effort that was the Fish and Wildlife Strategic Vision Project that resulted in the legislation that brought you to the work that you have already done. And I echo the remarks of others and with gratitude for that work. And I also echo the desire to see that brought to a close and to focus on the significant responsibilities the department has to protect biodiversity going forward. And I'm speaking today on behalf of the California Wildlife Officers Foundation and the Mountain Lion Foundation. And I just want to thank everyone for all of their efforts over this last decade to bring us to this point, and urge you to close the chapter on it. Thank you so much.
Thank you.
Okay, next.
Next looks like
Frederick Hall.
Paul.
Hello, Commissioner and board members. My name is Fred Hull on behalf of the Mountain Lion Foundation. And I also would like to take this opportunity to bring you to support bringing the reorganization efforts to a close, just mainly due to the allocation of already scarce resources within the department, stakeholders, and legislators. And just giving one example, for example, in the recommended changes, Section 4800 of the Fish and Game Code was amended for clarity, but it could potentially, after that amendment, have the unintended effect of allowing for the importation and possession of mountain lion parts, trophies, and as well as making it potentially more difficult to prosecute poaching cases. And also that code section was implemented by initiative in 1990 and requires a 4/5 change to actually make a change, 4/5 votes. So in conclusion, it would seem that the remaining recommendations are in place and could be adopted when a relevant code section is changed, as opposed to moving on all of the changes together. I thank you for your time.
Thank you. And I think
That's
Mark
it.
Blanchard? No.
No.
Okay. Any others? Hands up?
Chair, may I ask a question if
Of
there's
course.
no one left from the public?
Yeah.
It's directed to staff. I don't think the goal really should be enhancing organizational elegance, but enhancing the ease and effective use of the code by those who use it. And I'm struck by what sounds like unanimity here. Is there any constituent group that favors continuing?
No.
Okay, that would seem to answer the question.
I have a question also for Brian and staff. Based on what was asked of the commission to do you believe that we have accomplished that ask?
No. As gracious as the department's views on that point are, no, I don't think we have. The ask included improving the organization of the code. We bifurcated our comment review process to segregate organizational issues from non-organizational improvement in place. We've made no progress yet on the organizational issues.
In the past, where I'm assuming this is not the first time that we've had the public saying you don't need to continue working on this. What has happened in the past for studies where we have the public, no actual other group or agency advocating for the continuation of the study as asked by the legislature? What has been the process for that?
Other than the incident with the mediation confidentiality that I described, Can we mute him, please?
Oh,
That was not quite people saying that we need not do the work. It was more that they disagreed with where we came out on a somewhat binary reform question. So it's not quite comparable. But in that instance, we made our recommendation and it's on the shelf without enactment. I can't remember in the last 25 plus years, another instance where the commission's work was just flatly opposed and shelved. Well, now I'll take that back. When I first joined the commission, there were a few proposals. We had a change in composition of the membership of the commission, and there was a new interest in doing some sort of more business-friendly reforms. And the commission completed those and they went nowhere. Changing the business judgment rule, the unfair competition law, things like that, where the work just, but we did complete it. We made a recommendation. The recommendation just failed. I don't know of any other instance where we would just wholly table something based on unanimous opposition. I see a hand.
Yeah, Wendy?
Thank you. I don't know your protocols, and so
No, that's
okay,
fine.
thank you. I don't know how conversational you all are, and I don't want to.
I think what you did was perfect.
Okay, thank you.
Yeah.
You know, attorneys can read things in so many different ways, and right, like you all know that better than probably anybody. But when I look at the direction from the legislature to the CLRC to study whether the Fish and Game Code related statutory laws should be revised to improve its organization, clarify its meaning, resolve inconsistencies, make other minor improvements without making any significant substantive change to the effect of the law. I actually think that there is room, if you were to decide that it's time to pivot to something else, that to determine that you did actually fulfill that language and that the answer was no further changes.
The answer to the question whether.
Yeah.
Yeah, that's a legally defensible position. We could say, having made the attempt, we've concluded they should not be done.
Mr. Chair, may I ask a question? So it was mentioned during the public comments that a lot has been done. So what do you consider the substantive work that has been done that you're satisfied with?
May I answer?
Yeah, of course.
Yeah, so let's see, there has been at least AB 1527, SB 1473, a number of reports, the report also on unfunded mandates, and then the work that's underway right now, which we have, as you can tell, fully embraced and dedicated ourselves to supporting the commission, is what are going to be several hundred changes to text in place, which altogether would result in the largest number of changes to the Fish and Game Code from whenever it was first put into the current form of the code in the 1950s.
The first two bills she mentioned were the result of the commission in the process of working through the development of a proposed reorganization of the code, spotting issues that we thought would be beneficial to accelerate, where we thought, this is going to be a multi-year process to come up with this proposed new code, but these are things we could fix now in place and have immediate benefits. So the commission sort of did, as a sidebar, a couple of interim recommendations to propose clusters of specific changes. And I believe it was two bills that were proposed and they got enacted.
And it was to the code? What
Yeah, to the Fish and
specific
Game Code.
sections
I don't recall.
or divisions?
I
Okay.
don't recall.
Because I'm actually looking at the code online right now, and there's obviously several divisions from 0.5 to 13.5. And the memo that was submitted, or the document that was submitted, highlights Division 2 primarily, right? Division 2 and Division 2.5. And is that the only section that is in contention, or is all the other divisions?
Originally, it was everything. That was what we proposed in 2018. The narrower test case that was attached to the main memo is just Division 2. There was some discussion of possibly widening the aperture on that. And I think that's where section 2000 comes in, because I don't think it was within the four corners of the actual proposal. It was identified as a possible expansion, but it is just Division 2. That's the specific focus of today.
And if I may, that response to that was just an example of one of the issues associated with moving any pieces around additionally. That was just one section of the code, notwithstanding the idea to do more than that.
Yeah.
Of just the changes and the challenge that would bring for us.
And it sounds to me like the trigger here for the disagreement and contention is this, I'll call it concept, because I'm not very well versed in your code, but between conservation and hunting and fishing, it seems like that's the conflict.
I think the challenge from my perspective, and I welcome others, is that we've gotten to the place on the reorganization where there really just isn't room, with all due respect for this body, for there to be further reorganizations done here. And I think, Brian, you and your staff made a very fair shot, a kind of an experiment to
You
see
too,
if there could be,
with your involvement and help.
if there could be something that would be done. And it was really striking to us that even that very discrete challenge, that very discrete change, just reflected a lot of misconceptions about the code. And the distinction between hunting and fishing and conservation is one that's very impactful for our community.
Yeah, and I get that, actually. I see how that is, because sometimes how things are ordered or delineated in writing affect its meaning.
Yeah.
And I'm wondering, from the legislative side, have there been any laws recently enacted to distinguish between conservation and hunting and fishing? Because clearly that's the trigger, right, for the unintended consequences that you mentioned.
I think in this particular case, but I think that our strong feeling is that really at this point, any reorganization is in tension with the dedication of our staff to the mission-based.
So there's a forest and trees issue. I don't see a lot of point in digging in on specific objections they've raised to the proposal on the table when their opposition is at the forest level, which is, as Ms. Bogdan said, they don't think there's any room for organizational work, right? For all the reasons about their mission and their resources and value of that kind of work, et cetera. And so discussing the distinction between conservation and hunting, discussing the proper placement of the chapter on department managed lands, we could spend a few hours on that. I mean, all of those issues we could get in and we could test each one. I don't see the point because the opposition is not about that, really. I mean, it is about that too, but not in the main.
So I've read the same
paragraph about the direction from the legislature, whether Fish and Game Code should be revised to statutory law. And the list of 7 things, the first one of this organization. Is it the department's view that the code is perfectly organized and
No.
shouldn't be, should never be touched because it's so well structured that it's fine? Or is this, yeah, there's organizational anomalies in there, but it's just too costly for us to deal with it. I mean, it's our time, it's staff, it's knowing where stuff is.
I think it's a combination, and, also that perhaps the most appropriate body and process for working through to kind of move the ship
Yeah.
is a different one than this.
And what kind of process would that be?
I think the typical organic legislative process, which many of our stakeholders were on the phone today, appear that the Fish and Game Commission subcommittee process where ideas are developed and noodled around and come up organically. I think the work product that you've done would be a very helpful tool to assist those efforts as potential opportunities for revision arise. But I think as we saw in this particular discrete attempt, this is with all due respect, but this isn't a body that is best suited for tackling these efforts.
Okay, I get that. I guess I'm trying to struggle with if there is value at some point to some restructuring of it, how do we get there? I mean, I work in the legislature for like forever, and lots of education code. I probably wrote a lot of education code stuff, and so I'm trying to think through what would be an appropriate if we sort of conclude that the education code really kind of messed up. The stuff is where it doesn't belong, need to be. So what's the best process for sort of taking a step back and
I think you've
deep
done
breath
it.
and do it? Well,
You've given us a wonderful product. We deeply appreciate it. And that is something that we will carry with us and use as a platform.
No, I appreciate that. And I think all of us generally do appreciate all the help that you guys have given on us on where we are today. But my understanding is it's primarily sort of fixing glitches in place, right? It's anomalies and code section references and stuff like that. The how it ought to be organized as a big picture, I don't think we've dealt with.
Correct.
So do you think that there should be a process to take a look at the forest and not just individual trees? Or should we, I don't know whether it would be us or as a group of stakeholders or some combination or a legislative committee, or I don't know.
I think we're really lucky. I don't think there needs to be any additional process. I think we have the mechanisms in our department to make use of the product that you've given and incorporate that as we go. And, that's something that can be done in a way that harmonizes with our staff turning to the mission-based work that is so desperately needed to be done.
Yeah, no, I get that. And I'm sympathetic to diversion of resources from real resources to this kind of work. So
It's one of cost benefit analysis,
Yeah, no, I
right?
got
I mean, essentially, like Wendy works on all things water, right? Imagine that for the state and the role to protect fish and wildlife resources. And meanwhile, she's also spending thousands of hours. We just are not funded at a level to really do this justice, to work with your staff in a fruitful way that makes this, at the end of the day, helpful. And really, though, I think you said it best, while elegant and my type 1 personality would love to see it more organized elegantly, you're not going to get better responses to drought or wildfire or climate change or protecting endangered species through moving stuff around.
Mr. Chair, my question to staff about whether there was anyone speaking in favor really isn't and wasn't a political question. It's neither cost nor benefit. It's cost versus benefit. And we've heard a lot about the cost. Is there anyone who's speaking to the benefit of proceeding? And if not, does staff itself see a benefit?
Well, I would say the original recommendation of the Resources Agency's strategic vision process spoke to the benefit of improving the organization. They recommended that it be done. The legislature asked us to do it. So there's an initial sort of staking out of a position that this would be beneficial. At this point, no, nobody. It's not surprising though, because the benefits of change accrue mostly to the future rather than the present. Present practitioners know the messed up, inelegant system. They don't receive any benefit from having to relearn it. So it's a system benefit, and there isn't a constituency for that system benefit other than the legislature itself and the commission taking on that kind of work.
We saw that in the education code was revised, I believe, in 1976, and I came into this world in 1978. So it was, this was a new education code. This is the education code, and it's changed over.
My first year in law school, I got an assignment to research in the family code, and I was looking at it. I was like, who is this law revision commission that made me have to look at translation tables and research 2 sets of section numbers in the codes? So the costs are real. It's just a question of whether the long-term benefit outweighs the transition. And if you ask that question of current practitioners, their answer from their perspective is going to be no, it doesn't. We're fine the way we are right now. So I don't think you're going to have a constituency for change for the sake of systemic efficiency.
And I'll ask the other side of the coin. What are the consequences to the commission, to the staff, to the legislature, if we agree and we say, okay, we've completed our work, no more review? What are the consequences?
I guess I would say in the abstract, there might be a reputational hit to the commission for having wasted 6 years on work that didn't produce a benefit to the state. I don't know how realistic that is. We're toiling in our little corner, and I don't know who besides the people in this room are really paying attention to that. And they've assured us that we can declare success. So I don't think they're going to think badly of us if we decide to stop. That's the only consequence. We would forego the theoretical benefits of systemic improvement, but I don't think we'd pay a price for it.
And procedurally, would we have to file a memo with the legislature? Would be a memo to file saying?
That's a different issue, and I'd like to discuss that. If the decision is made not to proceed, whether or not we do something to formally close the file.
We've clearly heard that the department is stepping away from this.
Yep.
Does staff have the capacity to proceed without cooperation from the department?
Not very effectively. When we first started, and I promised myself to try and limit my comments today to where they're productive. So actually, I won't talk about that. I'll refrain. It would be hard because we can make our best crack, but as they've demonstrated today, our understanding is as educated amateurs and outsiders to the process. And what we would do without their assistance would likely miss the mark in a lot of cases. And so it would suffer. I think that there's some stuff we could do quite readily without their input, the nuts and bolts stuff, like breaking absurdly long sections into pieces and converting them into articles and cleaning up the cross-references. That kind of stuff doesn't have any, I don't think, has any scope for problems other than if we make just straight errors. The other stuff about, like, when you say group like things together, like, well, what are like things? And that's a call that we might make differently. And if we didn't have input from the department to tell us, you're making a mistake here, this is not a sensible organizational cut, then we would propose something that would maybe be counterproductive and would also likely provide fodder for opposition.
Hi, thanks. I have Commissioner?
Yep.
Chairperson, I have two questions. Going off of what you just said, Brian, first, I think I would be interested as a commissioner if what is being asked of us is to stop working, is to find out whether we can stop working and what are the consequences of that, right? That would be, if this is such a novel thing for the commission to deal with, I think it would be helpful to understand what we're required to do by the legislators asked of us. And I think that's the information I think we should have that information when making the decision whether to stop, I think, researching and doing something that we've been asked to do. My second, so if we have that information, that would be great. But my second question is actually for the amazing groups that are here today. In the event that Brian has just laid out a couple other technical ways that the staff could work without specific guidance and your support to keep cleaning it up in a way that addresses some of the organizational issues that we've been tasked to look at. Are you saying right now that you have absolutely no capacity at this time if we follow up at some point and say, we would like your comment on this very discrete issue? Are you saying, I want to just clearly understand, are you saying that at this time, you must withdraw from this process because of the lack of resources and the need to focus on more mission-driven work?
Just to be clear, we're already spending hundreds, probably thousands of hours on the text changes in place, right? This is, so we are pouring everything that we can into assisting the Law Revision Commission on that. And as I said in my email, I do not have the capacity to direct staff, and I don't believe that we have capacity within the department to continue to direct staff at anywhere near the levels that we've been providing assistance.
So Commissioner Carrion, your first question, I think, was to me about legislative guidance. I would say, I think part of the answer was pointed out by, I forget which of the witnesses read the text of the authorizing language, but it's correct that it's phrased as almost all of our grants of authority are phrased as whether something should be done. So it sort of contemplates the possibility that the answer is no, nothing should be done. We've looked into it and it is our recommendation that nothing be done. I think that would be a formal fulfillment of the duty to answer that question. I don't know that there's anything else the legislature would formally require of us. I do think it might be nice to memorialize that in some way, rather than just have an ellipse in our record. I did make an inquiry before this meeting with staff in Senator Laird's office. Senator Laird, who used to be an assembly member and who was secretary of the Resources Agency at the time of the strategic vision process. So probably the perfect person to get a temperature read from the legislature on whether they want us to do this. And unfortunately, I did not get a clear answer either way, which I expected that might be the case, but I also know that their staff was taken down by COVID almost like entirely during the period in which I was making that inquiry. So it may just be logistics that they couldn't answer us. I see a hand.
Yes.
And I have another just quick follow-up to that since it's related. At
Yeah.
this time, the staff does not recommended that we terminate, correct? This recommendation on the table based on the memorandum is to take a more narrowed approach.
That is the implementation of the commission's decision at the last meeting, which was based on a staff recommendation that we prepare a test case. As to what to do now in response to the feedback on the test case, I haven't expressed a recommendation. If I was pressed, I'd say, and I don't know how to separate the sort of my institutional commitment to the commission from my own personal take on the work and the future of that work. I don't relish the idea of doing something that is going to be opposed at every step without any supporting people, people stepping up to say, good, we agree with this. I think from the point of view of the legislature, who probably has not been particularly tuned into this, it would arrive on their desk as a very messy thing where we were saying, this is good in the abstract. And the Santa Barbara Zoo was saying, no, this is terrible. It's gonna endanger law enforcement and contribute to global warming or whatever the long list of arguments against. I don't relish that. My recommendation as a director of the staff would be, I would really like to put this behind us.
Yes, ma'am.
Thank you. My name is Angela Dublin, and I work in the legal office for Wendy Fonten. And I just wanted to address the question about whether or not you have the authority to not do something that you've been asked to do, like reorganization. I think it's important to note that while the reorganization that Brian is talking about is moving large divisions of the Fish and Game Code, you have made changes to the Fish and Game Code that do constitute reorganization. I was working on a section of the code the other day, section 3003, and I was citing the wrong section because I was thinking of what it was 7 years ago. But you guys reorganized that section, and you've done that to other sections. So it's just a matter of the hierarchy in the code that you're looking at. So you may not have moved whole divisions, but you have made organizational improvements and changes to sections and within sections of the code. And I don't think there's anything in your authorizing legislation that suggests that you have to make it at one level or another.
I think that's probably correct, that the earlier interim bills included a little bit of organizational cleanup, especially around sort of like the 200s, somewhere around there about the Fish and Game Commission's regulatory authority. I think we maybe did do some tidying of the organization there. But that was the limit of it. And I don't really think it's about the scale or the level at which we do it. I think the expectation was that we would make improvements throughout the entirety of the code. We're far short of that.
would it be appropriate for us, should we decide to not go forward, to tell the legislature, when they asked us whether the Fish and Game Code should be revised to improve its organization, yada, 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 to say, with respect to reorganization, no, doesn't need to do it at this time. No, I don't know, maybe at some future date, the department's going to have more money than they know how to spend and wondering what to do with all its free time. And
That'll be a great day.
I know, yeah. I know. Or leave that for another day for them to come back to us to say, well, how about let's reorganize the Fish and Game Code.
Well, we could say whatever we want.
Yeah.
In our concluding report. I don't really want to tie that question to the question of whether we continue.
Got it. Okay. So, commission members, thoughts about where we go the rest of the afternoon? What we do, how do you want to, Karen?
Oh, I just my brief comments on the reorganization. I just, obviously in our agency, we do a lot of thinking in terms of where to place codes, and there's a thought process behind where specific code sections are placed. And while I understand there's a need for reorganization, I think that has to have a benefit. And it sounds to me like there's not a huge benefit to spend a lot more time to do that. And so I would be in favor. I'd support Brian's, view on not proceeding. Also, because it is so old, it's highly unlikely that this is a top priority for the legislature right now. And our resources probably could be better spent on the other studies that they've recommended. So,
Yeah. Well, and I will say the experience here is coloring my ideas about how to proceed with the assigned recodification of the toxic statutes. We're breaking that into pieces. We're proceeding with smaller pieces. We're coordinating a little more closely with the affected agency. So, we've had lessons learned. I agree. I think the entire 2018 proposal is one, stale, right? So there's been change in the law. It would have to be modernized. That would be a lot of work. Two, it's just too big. I don't think there's any way you could drop a 1,200-page proposal on the legislature with one-sided opposition and even get a hearing.
Chairperson, I would like to make a motion, but I'm not sure if this is the best time because I recognize that not all commission members have indicated their opinions. So I'm happy to defer a motion. I'm happy to make that now to have further conversation.
Well, let's see if any other.
Steve has his hand up.
Oh, thank you. Thank you.
Jane? Did you say?
Steve.
Oh, Steve.
Steve.
Yes.
Hi, Steve.
Thank you. Hi. Thank you very much. I don't know if this is okay to contribute here, but I did want to offer some clarification. I'm primarily the staff member that's been working with several DFW staff council, and I think we've been doing great together. We've been making lots of changes, but I think this reference to organizational changes needs a little bit of clarification because there are some types of organizational changes which staff council have been tentatively agreeable to, where essentially we're fixing things which are broken in the existing code. For example, sections are misplaced. They're in an article or a statutory container where they clearly shouldn't be. And the meaning is very confusing because the title of the container directs the reader to believe that the items in the container are about one thing, and then this section is about something else. And then a more significant problem is a provision that might say something like, for purposes of this article, this definition applies. And the understanding is, and everyone agrees, the definition was meant to also apply to some other provisions which are not in the article. Or was not intended to apply to one particular section, which just got thrown into the article by mistake. So there are some organizational changes, which I think even the department would be happy with. It's just not this big structural improvement that would be at issue. And so I hope whatever decision the commission makes, it doesn't preclude that type of change that I've mentioned as being something that also can no longer be done, because there we're just fixing pretty clear mistakes.
Yeah, Wendy.
I think I'd like to just clarify too. I think, Steve, what you're referring to is the pending effort on the proposed changes to text in place that arose out of the notes that were part of the 1300. And we are committing to see that effort through with you all on the proposed changes that have been under discussion in the last year or so.
Okay, no, we appreciate that. Thank you. Okay, other.
My only comment is this, that I'm disappointed to hear a department say, well, we don't have any resources to help you through your study. And I understand what you're saying and where you're coming from. And all departments are understaffed, under-resourced. I've been a staffer before where I've seen many departments throughout my career say those things, and it's because they're resisting something. I think what I personally would appreciate is more clarity and honesty and authenticity about what exactly that you oppose, so that maybe there could be some work around it and we could deal with the smaller issues. It just, to me, doesn't sit right to hear, well, we're not going to work with you anymore. We're not going to help you anymore. That is just difficult for me to hear. And I get where you're coming from. You have a lot going on, but it's difficult to hear that, no, we won't work with Brian. No, we won't work with your staff on this. It just doesn't sit well with me. So whatever happens, I want you to hear that, because in my experience, that's not the issue. The issue is a bigger issue. And it sounds like you don't want to directly address it for some reason. And maybe I'm not understanding it. Anyway, that would be the only comment I have. It's just difficult to hear.
Okay, thank you. Anybody else? Jane? Anybody? Okay.
Commissioner Carrion was about to make a motion.
Make a motion?
Yes, I would like to make a motion that staff continue working on this project for the areas that it is able to do so without the assistance of necessary substantive comments from those organizations and groups that have indicated that they currently do not have the capacity to assist. And we take it step by step, and staff can determine in its work, whether it feels comfortable making any further changes without public comment or without the support of the people on the ground that work with this code day in and day out.
Can I maybe ask a clarifying question? Are you suggesting, because Steve and the legal staff in the department are still working on the fixes to sections basically in place, or if there's an error in the location, fixing that sort of, is that what you're saying that we should continue doing?
Yes, I believe that we should continue doing that, but specifically that staff should be given the discretion in really assessing whether they need the assistance of other practitioners in order to make any further changes. And if that's the case, then that can be assessed in the future rather than having a complete shutdown of the work, right?
Yeah, if I can help maybe
Yes.
clarify, one thing that I think is worth keeping clear in our heads is that we bifurcated this work into what I have been consistently referring to as phase 1 and phase 2. Phase 1 is comments in response to notes in the tentative recommendation that is being translated into specific, mostly textual changes in existing code sections. That's the work Steve's doing. The department has been stellar about helping us with that. All of the resource allocation that Wendy talks about, the thousands of hours, phase 1, okay? Phase 2 is improving the organization aside from those phase 1 issues. That's the part where the department doesn't see itself, I think, as having the resources to help. I suggested at one point, and I think this is what Commissioner Carrion is referring to, that it might be possible when I was asked a question about, like, could we do this work even if they didn't help us? And I said, maybe some kinds of things, like breaking up overlong sections, we could do without them helping. And I still think that that's possibly true. I don't relish it because I think any work we do on organization without their vetting and cooperation is going to wind up being opposed. And I see that. I think they've drawn a pretty bright line that they don't want further organizational work. And I think that if we try to carve off some segment of organizational work that can be done without their involvement, I think we're still going to face their opposition when we get to the legislature. I can't speak for them, obviously, except that that's how I understand what they've said. You know, and I think it is about resources. But I think it's not just that they don't have the resources to help us do further deliberations. I think they don't have the resources from their perspective to deal with the disruptive effect of changes to their code that they don't see as having sufficient value. Right? So I don't know that we can split the baby and somehow salvage some piece of it. And as I said this morning, antitrust, equal rights amendment, landlord-tenant terminology, we are going to be jammed up very soon. And I don't want to spin wheels on something that isn't going to get traction.
So basically you're saying we'll finish phase 1 and they've been of enormous help.
Yep.
But phase 2, we just
write a coda and be done.
Okay. Is there objection to proceeding in that way? That we continue our work with the department and all the stakeholders on phase 1, but park phase 2.
And I'll revise my motion to that language.
Seconded.
There's been moved and seconded. Any questions or comments from commission members?
I'll call the roll on this one.
Okay.
Commissioner Carrion?
Aye.
Commissioner McAllister?
Aye.
Commissioner Hebner?
Aye.
Commissioner Jenkins?
Aye.
Commissioner Simpson?
Aye.
Commissioner Cubis?
Aye.
That concludes the memo 30 and its 5 supplements. Steve still has a little bit. We've got 30 minutes left on our allotted meeting time. More than enough to handle the phase 1 work, which has been proceeding on a consent basis.
Are you ready?
I want to, before, thank the department for their input, both on this phase 1 stuff, as well as, you know, the structure and how this kind of sort of phase 2 work could affect what you do and what you need to do and so.
And to you.
Steve.
All right. So we have 2 last items here under Fish and Game. the two memos, 2022-28 and 29 are recurring memos that you've seen pretty much every meeting. The first presents proposed revisions along the lines that we've been talking about in the last part of this meeting, or some specified treatment, either for inclusion in a draft recommendation, for exclusion from the draft recommendation, or because based on the comments from the department or the Fish and Game Commission, we need some further input. And so we've now been through all the initial comments from both agencies. And so what I'm doing now is I'm working on that last category, which is the further input. The further input takes three different forms. The original classification of further input were provisions where the comment that was made, either we didn't understand it, commission staffs didn't understand it, or we thought that perhaps the department staff or the Fish and Game Commission staff didn't understand it. And so we wanted to be able to speak to them and see if there was some way to work things out. Then we had provisions in which the note in the tentative recommendation, it indicated we've changed the language of this existing section. Is that caused a substantive change? And the response was no, it hasn't caused a substantive change, but there was no express approval of the revision. So we needed to go back and find out whether there was any other problem or some reason to not make the revision of the existing section. And then finally, we've had provisions in which commenters have said, yes, that revision is fine as it was expressed in the tentative recommendation. The problem is that we then have to sort of translate that revision in the tentative recommendation, in which we were writing new sections to do strikeout and underscore on the existing sections. So also, again, we have to get a sense from the commenters about whether the way we've done the revision is appropriate. So where we are now in this study, this part of phase one, is that we are now getting the input back from the commenters, and we are sort of inputting that comment in, then making sort of secondary and hopefully final or near final proposals to the commission about what to do about a particular section. Sometimes after the discussion, the recommendation from staff is don't make this revision. Most times, hopefully it is after discussion, staff is proposing that the following revision of an existing section be made. So in 22-28, we have a series of proposed revisions, which are all revisions which are at least been approved in principle by the commenters. They have not yet seen the final language in the existing revision of the existing section. And so we've asked for provisional approval from the commission of all the sections which are listed. But there's a very good chance that these revisions would all be approved. And if they are approved, they would then go into the cumulative draft, which is what's in the second of the two memos, 22-29. So that's where we are. And as it happens, this first memo, 22-28, the only recommendations are provisional approval on a consent basis of all the revisions that are proposed to existing code sections. So as we've been doing in the past, I won't discuss any of them individually unless anyone has any questions or comments. I'm certainly happy to address any questions or comments. But otherwise would ask for provisional approval that all these revisions be included in the draft recommendation, subject to a final approval by the commenters.
Okay. And Mr. Chair, just a point of clarification, are we talking about moving approval of the memo 22-29?
That's only an informational memo. There's no approval needed to that.
Subsequent memo, so 22-30.
That's what we just talked about.
Oh, I
They're
see.
talking about 28 only.
I see.
28 only, which Steve's looking for provisional approval by this body, pending the opportunity for the department and other stakeholders to look at the final language to make sure that there aren't any glitches in that.
Okay, I'll go ahead and move it for approval.
I'll second.
Second by Jane.
It's hard, it was hard to see any hands. I don't know, did anybody, no one has any questions, right?
No.
Comments, okay. All right, great. Roll call, just go off the list on our website. Commissioner Simpson.
Aye.
Commissioner Jenkins. I'm sorry, I didn't hear or see something.
Aye.
Okay, thank you. Commissioner Carrion.
Aye.
Commissioner Kuas.
Aye.
Commissioner Hebner.
Aye.
Commissioner McAllister.
Aye.
Excellent. Okay, and so again, 2229 is just informational. Certainly, if there are any questions or comments about that, I'm happy to respond. But this is just presentation of the latest version of the cumulative draft. So all the provisions you approved in 2228, assuming they're approved by the commenters, will go into the cumulative draft that you will see at the next meeting.
Okay,
Great.
great. Thank you, Steve.
All right, thank you.
I think that wraps it up. Thank you to commissioners, to all the folks who showed up here, as well as those online or video or whatever, by phone.
Yeah, it worked.
It worked, yeah. Any other comments for the good of the order? Hearing none, seeing none. We are adjourned. You're here.
Thank you. Bye, everyone.
Aye.
Brian, can I end the meeting?
Yeah, end the meeting.
All right. Anyone who's inclined, there is a sign-in sheet if you're so inclined.
Well done, Chair.
Yes.
Yeah.
That's fine.
One, I
It's okay, like we were all together.
Yeah.